Thanks for coming. I'm Nicole, Pallotta, Academic Outreach Manager with Animal Legal Defense Fund. As you may have heard throughout the weekend, the field of animal law has grown tremendously in the last decade and a half, and educational opportunities continue to expand. In 2008, the inception of the Center for Animal Law Studies at Lewis & Clark in collaboration with ALDF was an important milestone that broke new academic ground by creating the most extensive animal law curriculum in the world. More recently, Harvard Law School has emerged as an academic leader with the launch of its new Animal Law and Policy program. And ALDF's Animal Law program has been dedicated to supporting the future of animal law since 2000, the year 2000. You may have heard this also during the weekend, the statistic, but in the last 16 years since ALDF started tracking, the number of student Animal Legal Defense Fund chapters has grown from 12 to 215. And in that same time frame, the number of law schools offering at least one course in animal law has expanded from 9 to more than 160. So in light of the incredible growth of student scholarship and interest in animal law issues, we decided for the first time this year to organize a panel devoted to showcasing student work at the Animal Law Conference. So this spring we announced a call for papers written by law students in the last 2 years on any topic in animal law, and a panel selection committee composed of practicing animal law attorneys and professors reviewed and ranked these papers. The top 3 were written by those that you see before you here, and 10 additional papers received an honorable mention, and those papers are posted on the conference website under the resources section, along with the 3 that will be discussed here today. And I encourage you to check all those papers out, and thanks again for coming. And I want to introduce our panel moderator, Rebeka Breder. Rebeka Breder is an animal law and general litigation lawyer at Boughton Law Corporation in Vancouver, BC. She founded the first Canadian Bar Association Animal Law section in Canada and remains its chair. She's currently on the board of directors of the Vancouver Humane Society and has been a passionate advocate for animal rights since she was a little girl growing up in Montreal. Rebeka advises clients on a wide range of animal issues, including dangerous dog defense, animal guardianship, veterinary malpractice claims, custody of companion animals, wildlife, and issues around exotic and captive animals. Rebeka also served on the selection committee for this panel, and now I will turn things over to her. Thank you.
Hi, I'll be very brief. Just to emphasize that there were about 34 papers in total. There were 3 of us who reviewed the papers. They were fascinating. It was really hard to pick. But we did it. We picked the top 3. It was, I'll spare you the details how we actually got to, how we actually selected it. It was like this complicated matrix with a whole bunch of numbers. So I'll spare you that. But a lot of thought went into it, and we're really happy to have these 3 presenters with us. I thought I'd read a little bit about who they are. And I apologize, I do have to read it because they've done such wonderful things, and I want to make sure that I don't forget any details. Angie, who will be speaking first, she graduated from Lewis & Clark Law School in 2015 with a certificate in animal law. During her time in Lewis & Clark, she participated in the Animal Law Clinic and the Kenya Legal Project. Her experience studying in Kenya inspired her to write the paper that she will be presenting today, which was also published in the Animal Law Review. She was also on the editorial board of the Animal Law Review and the SALDF, and an SALDF member. After law school, she also earned an LLM in taxation from Chicago-Kent College of Law in 2016. And while doing her LLM, she externed at the IRS Office of Chief Counsel. Angie is currently working at Ernst & Young on their state and local tax real estate team. She's admitted to practice law in Illinois. So is that kind of accurate? And I
Yes.
should say we didn't actually ask them if all of this is accurate. So if there are any inaccuracies, let me know. Caitlin, who will be going second, sitting in the middle. She is a 2016 graduate of the University of Chicago Law School. While at the University of Chicago, Caitlin was an SALDF board member as well and serving as co-president of the Food and Drug Law Society, volunteering for the International Refugee Assistance Project, and working on the University of Chicago Legal Forum Student Journal, where her article a 26th Amendment challenge to state voter ID laws, was published in 2015. While pursuing her degree, Caitlin interned for the ALDF's litigation program, as well as for U.S. Senator Richard Durbin's Judiciary Committee. After law school, she joined Perkins Coie, or Coie, I'm from Quebec in Canada, so we say Coie, as an associate in the corporate litigation group. Elizabeth, sitting at the far end, is a 3L at the John Marshall Law School, where she's pursuing a JD and an LLM in real estate law. She's president of the real estate law student group at JMLS, the Marshall Law School, and a member of the school's SALDF chapter. She was the executive lead articles editor of the school's law review. She also interned in the U.S. District Court of Northern District of Illinois for the magistrate judge Jeffrey Cole, and most recently interned for the Illinois Department of Healthcare and Family Services Bureau of Administrative Hearings. Prior to attending law school, she graduated with honors from the Academy of Dog Trainers and acted as a consultant to animal care facilities and no-kill shelters to help improve their animal care and training programs. She has also been featured on TV and radio advocating for the use of humane dog training methods across the training industry, which is probably no surprise why you wrote your paper on the topic that you did. So without further ado, Angie will go first.
Thank you. Hi everyone, I'm Angie Ostrowski, and I was randomly selected to be the first speaker of the panel, so hopefully I'm not too nervous, but I am excited to share my paper with you. It's called Elephant Death and Taxes, Proposed Tax Treatment of Illegal Ivory. I'm sure you've all heard some variation of the famous Ben Franklin quote that nothing can be said to be certain except death and taxes. Now, unfortunately for elephants today, death at the hands of poachers is fairly certain. However, on the other hand, for poachers and ivory traffickers, taxes on their illegal activities are far from certain. So hopefully we'll be able to reverse that, and death to elephants will not be certain, while taxes on the illegal ivory trade will be certain. So just to give a brief background about myself, I was a business major in undergrad, and I never had any interest in going to law school. My plan was to get a master's in accounting and become a CPA, but then I found out about animal law somehow, and I was really interested in that because I've always loved animals and wanted to do more to help them. So I felt like using the legal system would be a good way to have a big impact on a lot of animals. So I went to Lewis & Clark and got my certificate in animal law in May of 2015. However, I decided to, I took federal income tax in my 3L year, and I decided that tax law really made a lot of sense to me, and it was what I needed to be doing, so I decided to pursue an LLM in tax, and now I'm working at an accounting firm in their state and local tax group. So my presentation today is not going to be too tax heavy. I know a lot of people either aren't interested in tax or find it boring, so I'm just going to cover why it's important to protect elephants, the international ban on the ivory trade, and what the U.S. has done to ban ivory trade, and then briefly discuss my proposals. So just to go over the inspiration for my paper, when I was studying at Lewis & Clark, I had the honor of participating in the Kenya Legal Project, and it was a group of 8 students and 2 professors, and we spent 2 weeks in Kenya learning about the legal issues that they faced from poaching and the ivory trade. And while we were in Kenya, we visited the David Sheldrick Wildlife Trust, and basically that's an orphanage for baby elephants. Most of them are there because they lost their families to poaching. So it's very sad, but these are some of the babies. They spend their days out in the national park, working on being rehabilitated to live in the wild again once they're old enough. So these are the elephants. I mean, it's hard to tell from this picture, but they're running back to their nursery so they can get their bottles of milk at the end of the day. So it was really exciting to see this. And then this is one of the baby elephants. She was not even a year old yet, so she was too young to go out with the other elephants, and she was already sleeping under her cute little blanket by the time we got there. So first, the importance of protecting elephants. There are many reasons why it's important to protect elephants. These are just a few of them. From an animal rights perspective, it's important because each individual elephant has inherent value. From an environmental perspective, it's important because elephants are in danger of extinction, and so we need to protect them from that. Right now, they're being killed at a rate of 1 elephant every 15 minutes, which is about 36,000 elephants a year. And if things keep going at that pace, they will be extinct from the wild by 2025, so 9 years from now, which is scary to think about. It's also important to protect elephants from an ecological perspective. The subspecies forest elephants help the ecosystem function. They eat fruits and then they poop out the seeds and help the plants grow in the forest. It's also important for the economy. So when we visited Kenya, we learned that wildlife tourism is a big part of their economy. And elephants are worth more alive than dead. So a live elephant is worth about 76 times more than a dead elephant. So, that's just another reason to protect them. And then finally, there are a lot of criminal and terrorist organizations like Al-Shabaab that have realized the monetary benefit of trading in ivory and poaching. So they have, gotten a lot of funding through funding people to sell ivory to, foreign countries. So if we protect elephants, then, we're also helping to defund the criminal organizations. Okay. So just to talk about the international ban on the ivory trade, CITES is a conference on international trade in endangered species of fauna and flora. And so it's an international treaty that countries voluntarily adhere to, and they enact laws at their national level to help enforce the treaty. So African elephants were first listed under Appendix 3 in 1976, and this provides the lowest level of protection to a species. And then in 1977, African elephants were moved to Appendix 2, which gives a little bit stricter protections, and then in 1990, the African elephants were relisted under Appendix 1, and this is what's known as the global ban on the ivory trade, because species under Appendix 1 are both the animal and products made from the animal are banned from trade. However, unfortunately, the ban worked so well that there were certain countries that wanted to move their elephant populations back down to a lower level of protection, and so Botswana, Namibia, and Zimbabwe got permission to move their elephants back down to Appendix 2 in 1997, and then South Africa moved its elephant population in 2000. And then along with that, CITES approved some one-off sales from these countries. They had government-owned ivory stockpiles since the trade in ivory was illegal. They had no way to sell it, so CITES approved sales of these stockpiles to Japan and China in 1999 and 2008. And since then, there's really been no decline in the demand for ivory. Poaching has been increasing at alarming rates. So there's still more that needs to be done to protect elephants. And then just recently, in the past couple weeks, there was another CITES conference of parties, and Namibia, South Africa, and Zimbabwe requested CITES to do another sale of their government-owned ivory stockpiles, and fortunately, that was denied, so that's a good thing for the elephants. And then after the elephants were moved to Appendix 3, some countries burn their ivory stockpiles just to show their support that they don't encourage poaching, they're against it. And so the picture on the left is Kenya's, the remnants of they were the first one to burn ivory stockpiles. And so in their Nairobi National Park, they have a monument to this, and so this is just a pile of all the ivory they've burned, and it just sits there as a reminder of how destructive poaching is. And then on the right, it's just a close-up of the ivory, and it just looks like little rocks and stones. You wouldn't ever think that it came from an elephant. So recently, the U.S. has also taken action to ban ivory. In July 2013, President Obama issued an executive order to reduce the demand for illegally traded wildlife in the U.S. and abroad. And then in May of 2014, the Fish and Wildlife Service issued a director's order to enact a ban on the commercial trade of ivory. And then just a few months ago, in June of this year, the Fish and Wildlife Service enacted their final rule, which created a near total ban on the commercial trade of elephant ivory in the U.S. Unfortunately, there are still some exemptions for ivory legally acquired before the ban from CITES. There's an exception for antiques and items with a de minimis amount of ivory, and then also, unfortunately, sport hunted trophies are still allowed to be transported back into the U.S. And then finally, just last month, both houses of Congress passed the Eliminate, Neutralize, and Disrupt Wildlife Trafficking Act, and this supports global anti-poaching efforts, and it was just sent to President Obama on September 29th. So hopefully he will be signing that, since it is in line with his executive order, and we will be hearing the results of that soon. So based on all of this, the international ban is not working. There's still ivory being sold. The U.S. is taking action, but ivory is still an issue. So I propose tax treatment. Taxes are often used as a way to disincentivize people from taking certain actions. So I thought, why not, propose more taxes on the ivory trade in a way to help, reduce the market. And one of my proposals is to deny deductions for business expenditures to those who deal in illegal ivory. This is similar to the denial of deductions for certain drug traffickers. So I think certain controlled substances such as marijuana, dealers in those don't get business expenditures, so it would be easy to just take the language of that law and apply it to the ivory trade. Another option is to deny restitution as a business expenditure to those who deal in illegal ivory. Sorry. And then another option is to impose an excise tax. So excise taxes are often imposed on products or services that are considered to be having adverse effects on either the environment or society. So, things like cigarettes, alcohol, guns, even tanning beds have excise taxes attached to them. So, it's been shown that the ivory trade has an adverse effect on the environment. So imposing an excise tax could be, one way to help deal with this, and then also can do a corresponding occupational tax on the dealers in ivory products. Another way is to work more on prosecuting ivory traffickers and dealers for tax crimes. such as tax evasion and tax fraud. You know, it's, for whatever reason, it's usually easier to successfully prosecute people for tax crimes than for the underlying crime that's connected with that. A famous example is Al Capone. He was, finally convicted of tax evasion instead of any of his mobster-related activities that he participated in. So that's another way to go after ivory traffickers. And then my final proposal is to offer tax credits to individuals who relinquish legal ivory. So there are a lot of musical instruments and guns that have ivory components, and the ivory isn't necessary for these to function properly. So if individuals willingly give these up, then they can get a tax credit and use that to purchase new products that are ivory free. So those are the proposals that I have come up with, and I'm sure there's even more ways to use the tax laws to help disincentivize people from trading in ivory. And then just gonna end with a nice picture of happy elephants in the wild where they belong. Thank you.
Hello, my name is Caitlin. I am from Philadelphia, so I'm going to try my hardest to say water and not water, because I'm just talking about the Clean Water Act. So I'm going to be talking about the regulatory regime surrounding feedlots, or concentrated animal feeding operations. I know this was discussed a little bit yesterday, but I'm going to be talking about mainly the Clean Water Act and how to contain the negative effects created by KFOs. So that was also, Food and Water Watch is a great graphic showing the density of concentrated animal feeding operations, KFOs, across the United States. It's actually really disturbing, but if you want to take a look, that was the previous slide. So they're everywhere, especially in the Midwest. So some history. So KFOs didn't always exist. Before the 1900s, most people didn't actually consume that much meat. Cows were usually raised and brought to slaughter by cattle drives, and there was no refrigeration, so you couldn't slaughter and then ship meat across the country, which kind of limited meat consumption. Gustavus Swift invented the first feedlot in the south side of Chicago in the mid-1800s, and this is when meat was revolutionized as a commodity that you could slaughter and then ship using trains that were refrigerated by the train's movement and air refrigerating the meat. So industrial meat production really increased after the Industrial Revolution. So in the 1920s, it increased greatly. World War II, industrialization and mechanization of most of the processes increasing meat production. And the Green Revolution in the mid-1940s and mid-1970s introduced synthetic fertilizers into agriculture, which increased the ability to grow large amounts of corn, which meant you could feed more meat cheaply. And the modern feedlot is now a result of this great revolution in how you produce corn, and also veterinary medicine. Because if you're growing animals in dense concentrations, usually you have to apply antibiotics to keep sanitary conditions from affecting them. So, what is a KFO? So before you're a KFO, you have to be an AFO, which is an animal feeding operation. And this is a definition usually applied by the EPA. And it's important because if you're not a KFO, then you can't really be touched by some of the environmental laws that the EPA has to regulate you. So a KFO is an AFO, an animal feeding operation, but it has to meet certain size requirements, and it also has to discharge waste into federally regulated waters.
Sorry, I'm just gonna turn the mic up.
Yeah.
Sorry, guys.
Thank you.
It's a little hard to hear you.
Okay.
I don't know if this is any better. Go ahead. Gentlemen.
Hello? Can you hear me a little bit better? No?
Yeah. That's
Okay.
better. Okay.
Sorry. So an AFO is mostly defined by being agricultural, raising animals for food in dense concentrations. There's no grazing, so there's no pasture that these animals are being raised on, and it's a small land area. And for EPA regulations, there's also the requirement that they're confined for 45 days in a 12-month period, and there's no vegetation. So there's a picture of a KFO. And the size requirements for KFOs are not that much, but you'd be surprised. There's about 5,000 identified KFOs in the United States. And you can be large, medium, or small. And you can see the size requirements differ based on what type of animal you're growing. So if you're a large or medium KFO, you're subject to regulations by the EPA. If you're a small KFO, which is still a vast amount of animals, for instance, turkeys, you can have less than 16,000 turkeys and still evade EPA regulations. So I think we all know the effects of feedlots. Just briefly, environmental effects, health effects, both for the animals and for the workers who are working in it, including mental health effects. There's lots of animal abuse inherent in the system, also intentional animal abuse. Water is a huge issue, and also the effects of people who are living near these areas. So these are just two graphs showing you all of the diseases that can be transmitted by KFOs to people working in them or around them. You don't have to read it, but it's a lot of disorders. And also, there's a huge economic cost to KFOs. You would think that KFO operators would champion that they're creating jobs for the people working in the KFOs, for the people surrounding the area. But most people who live near KFOs don't actually work in them. Usually it's seasonal workers or illegal workers. And it drops the property values of the people who are living near the KFOs. So they're really in this position where they're not being employed by the KFO, and they're losing the property value because they live nearby all of these negative externalities. So this is just a quote from a case where the citizens sued a KFO for nuisance because of the negative environmental effects and economic effects that was caused. So who regulates KFOs? Well, a lot of people regulate KFOs in different ways. It's kind of a mishmash of regulations that makes them be able to pretty much be unregulated. So the EPA in the states regulate the water and the air. USDA, kind of simplified, regulates from slaughter to shelf. So they regulate the slaughter of the animals and then the labeling of the meat. And the FDA regulates the antibiotics used and also the feed that you can feed to the animals, because oftentimes that also contains antibiotics. And the antibiotics, for those who don't know, it not only keeps them healthy, it also speeds up the fattening of the cattle. So, how are they regulated? So the EPA, we're going to talk about how they regulate under the Clean Water Act, because it's probably one of the acts that touches upon KFO operations the most. But as you can see from this quote by Congressional Research Service, agriculture is virtually unregulated by the expansive body of environmental law that's developed in the past 30 years. So these 4 acts do regulate. The EPA could use them to regulate feedlots. We're only going to talk about the Clean Water Act. So under the Clean Water Act, agriculture is generally exempt. If you're a small farmer, you don't really need to comply with the environmental regulations. In 1976, the National Pollutant Discharge Elimination System was created, and this required permitting by point source polluters. So point source, you need a permit when you discharge waste into federally regulated waters. This means you need to tell the EPA, I'm dumping this waste in water. And unlike human waste, waste from farms does not need to be treated before it's dumped. So all this untreated waste, which probably contains antibiotics or other diseases, is dumped into federally regulated waters. And under the NEPDES program, NPDES, KFOs are defined as point sources. So they cannot discharge into federally regulated waters without a permit. But you have to meet the KFO definition. So if you're an AFO or a small KFO, 16,000 turkeys, no permit. You can just dump your waste into federally regulated waters. So the permit issuing authority is technically the EPA, but most states actually regulate the permit system. I would say, I think last time I looked it was 45 states control the permitting system, which means the EPA is not the oversight body. So the states do have to issue permits in line with what the EPA does. They can do stricter as well, but they have no incentive to find KFOs in order to require and make sure that they're permitting. So the permits also regulate the effluent limitation guidelines. So you can't just discharge, get a permit, say, and discharge whatever volume of a particular waste component, like ammonia for instance, into water, you do have to be under a certain level. So the EPA has not been great about regulating KFOs. Prior to 2001, only livestock was regulated, so all poultry operations were exempt. So they were sued by environmentalists in 1991, and because of this, they updated the regulations in 2003, and this incorporated poultry into the NEPTIS program, so they had to get a permit to discharge, and they had to submit a nutrient management plan, so how they were going to deal with all the waste they were generating on these farms. But environmentalists and the industry sued, and in the Waterkeeper Alliance, KFOs were, the KFO regulations were vacated by the Second Circuit. So in 2003, the EPA tried to do this great thing by saying all KFOs must get a permit unless they can demonstrate to us that they're not going to discharge. So it's not a ex post system anymore. It's not you discharge and you get a permit. Even if you're not currently discharging, you have to prove to us you're not, or you have to get a permit. This is great because it's an identification system. So KFOs we don't know how many there are even in the United States, but the EPA could track how many KFOs there are because all these KFOs would have to get a permit even if they weren't discharging. Under the Waterkeeper Alliance decision, the Second Circuit said, nope, you can't do that. You can only require KFOs to get permits if they're already discharging. So, 2008, the EPA tries again. And they say, okay, we're going to require KFOs to get a permit if they propose to discharge. And this was a lenient standard even under the EPA because it was assessed by the KFO operator. So the KFOs were essentially self-reporting, which they have little incentive to do. In 2011, industry sues again. This portion is vacated, and they tell the EPA, no, you have to actually discharge to get a permit. So what this means is that a KFO operator, who the EPA doesn't already know and is not already watching, could discharge and not have a permit. There's no way for the EPA to gather information on what KFOs exist and what they're doing unless they already know about them. In 2012, they tried to rectify this by establishing a KFO information database and expanding the farms that were subject to the scheme. Unfortunately, they then rescinded their efforts because of industry pressure. So right now, we don't know how many KFOs exist unless they're already under a permit system. The EPA is not the one regulating them, usually the states. What this results in, more than 60% of KFOs remain unregulated, more than any other point source in the country. It says the 2003 rules have been watered down so much that the only regulatory burden is faced by people who live near these facilities. So, how can we regulate them? Well, KFOs are sometimes regulated under nuisance law, which has problems of its own. But people living near them can claim that they create unreasonable interference with their health and well-being, with their enjoyment of the property, and try and get the KFOs either to pay damages for the property value decrease or leave. But it has its problems. Boards of health can regulate them, but they can't conflict with state rules. So boards of health can monitor the water discharging near the KFOs and take action. State actors, there's not a lot of incentive for a state to do this. When they don't regulate KFOs, they're protecting industry. So I would argue that maybe they shouldn't be the ones in charge of regulating them. There are some states that have more strict permitting requirements, like Michigan does require KFOs who aren't currently discharging to get permits. But most of them do not. They're under-regulated. But they can establish stricter water pollution standards. There's also ballot initiatives. So 24 states, I think the number is, have ballot initiatives where citizens can create their own law, essentially. And they can impose stricter requirements, but they can't conflict with federal law. So the challenges to regulating KFOs any further are invested industry. It's a very powerful industry that's remained unregulated pretty much in the environmental sphere. I mean, agriculture is generally exempt. And unless you're a certain size and people know that you're a certain size and you even exist, you're probably going to go under the radar under the Clean Water Act. Ag laws prevent the accumulation of documentation from these farms by restricting the recording and requiring strict reporting requirements when you record what's going on inside a KFO. Right to farm laws have pretty much made nuisance claims kind of redundant. They protect the right to farm from nuisance claims. Established this pretty much is not a nuisance. Some people say paternalism. We want to farm. You can't come in and tell us how we're supposed to raise our animals. But the biggest challenge is probably information gathering. We don't know how many KFOs exist. The USDA doesn't even know how many farms over a certain size exist. There's not enough money for enforcement, for gathering how much pollutants are entering the water. So information is a huge component, and the EPA does not have a way to gather it. So how should they be regulated? There's lots of ideas thrown out there. Environmental approach, if people believe in the EPA, Congress could strengthen their authority, allow them to gather information, allow them to get permits even if you're not currently discharging. They could also tie this to grant programs. So they talked a little about NEPA yesterday, where if you're using federal funds, sometimes you have to submit an environmental report detailing how you're going to use those funds. It's kind of a similar idea. If you're receiving federal money, maybe you have to comply a little more strictly with environmental standards. You could also do this with commodity subsidies. You end how much money you're subsidizing corn, and maybe down the line this decreases how many animals you can grow in a feedlot. There's also an animal welfare approach. Labeling, something that they do in Europe is they have a standard, kind of like a green label, where they say how much environmental pollutants was created or went into creating this product. Could do that, but that requires FDA or USDA approval. There's also a health and safety approach. There's this thing called site scoring, where the EPA could use a system where they, for a KFO to operate, it needs to meet a certain amount of beneficial points. So for instance, an X number of animals or under a limit of discharges into waters. So there's some ideas. I'm not particularly hopeful about any of them. More pressure needs to be put on the EPA and Congress, which is a problem.
Okay. Hello, everyone. I'm Elizabeth Foubert. I'm really excited to be here. I feel very honored. The paper I wrote here on occupational licensure for pet dog trainers, dogs are not the only ones who should be licensed, is really a culmination of about 15 years of my experience being a pet dog trainer. Before I was a law student, I was, many years back, I was working on my undergraduate degree in psychology, where I got introduced to the learning behaviorists of B.F. Skinner and Isaac Pavlov, and at that time I was, considering being a counselor in another sense, right? In the profession of psychology. Now I'm going to be a counselor in law. But when I got out of college, I really didn't see myself going into the profession of psychology, and I did, however, have a wonderful dog once I could get my own apartment and convince the landlord that I could have a pet. So, and of course, being the responsible pet owner, I needed to do training with my dogs. So I went to a training class, and right from there, this is my calling, and so I thought, wow, this could be a great profession, and I was in San Francisco and found myself at the San Francisco SPCA, where I was set up to begin volunteering to help with the dogs there, and that facility is they have a Maddie's Adoption Center, and it's state of the art. Dogs aren't in cages, they're in suites. They're really trying to rehabilitate the dogs, get them in forever homes. And I was exposed to that, and they have an academy for dog trainers. So through that program, I was so pleased again to see that all of the psychology that I had learned really came back, because what we know about training animals, what we know now about learning theory is that we can really do humane training with dogs that is very opposite to what many people have learned over the years with sort of this dominance model that was out there on how you have to train dogs. So that's a little bit about where this came from. And then I was in my candidacy year for law review, and I got the opportunity to write on any topic that I wanted to in the law, and I thought this would be a great area to research further. So they said I just press it and I get the next screen. Oh, there it is. So there's a long tradition of citizens esteemed by the professional colleagues devoting time, energy, and talent to enhancing the dignity of their calling. And that's what this paper is about. I really want to help create a better conditions for dogs in their homes, how they're being trained, because there is an issue, and I'm not sure that many people are really aware of it. So we have, here are some numbers. People like numbers. 70 million dogs living in over 43 million homes across the United States. You know, they're our companions. They're everywhere, and they seem to have a kind of cushy life. You know, look at the pet stores with all the beds and the doggy daycares and the massage, and it's fabulous. They do have a lot of things really going for them, but we can still do better. We see dogs are increasingly being used, you know, as emotional support therapy. They're everywhere. They're in classrooms, they're in hospitals, they're on airplanes. And still, annually, over $1.2 million, 1.2 million dogs are euthanized in animal shelters, and due in part to behavior problems. And currently, and this was the shocker to me when I was studying to be a dog trainer, is that states do not require a licensure to be a dog trainer. Anyone here right now, you know, go right now. You can just print up a business card, get a website, and call yourself a dog trainer. And I think that's pretty terrifying for the dogs. So it's really been you know, I'll let the buyer beware, caveat emptor. And so my paper, you know, talks a lot about consumer protection and the need for this licensure, but the ultimate consumer is the dog. The dog is on the receiving end of people who are training, who are holding themselves out to be experts, who may in fact be using training methods that are bringing harm to the dogs, that are stressful for the dogs, that may not help a problem, may make a problem worse, may end up with that dog being relinquished to an animal shelter, unable to find a home, and being euthanized. So I propose that greater consumer protection is needed for dogs. So this is a client of mine, but what we knew about dogs, which I think is there's a lot of misconceptions out there. I think the public is confused because, again, there's really no regulating of this. There's been the traditional model that dogs are, we compare them to, and we all know that they descended from wolves, but that was a long time ago. In fact, it was over 125,000 years ago. And there was, in the World War II, dogs were used in combat, and there were approximately 25,000 dogs used in the military. Not soft dogs, though, hard dogs, tough dogs that could withstand a lot of, jerking motions, helicoptering. There's a lot of physical manipulation of the dog to make the dog behave, submit. And there was, again, this whole approach that, comparing the dogs to wolves, and that this idea that they need to be dominated. Comparing dogs to wolves is as relevant as comparing humans to chimpanzees to explain behavior. It really doesn't apply anymore. And we've learned a lot from the work of B.F. Skinner in operant conditioning and learning theory to know that, and unfortunately that lots of animals suffered, right, with those if you took Psych 101, you learned about, the animals getting shocked, for if they did this behavior versus another. And then we learned about reinforcing behavior, and we know what punishment does, and we know what what reinforcement does to behavior. And so we can take that science and we can really apply it to dog training to make a humane way of dealing with dogs. And let's see. So what we know now, we know that dogs, they self-domesticated. Like I said, 125,000 years ago. They're not wolves. the dominance-based models are not sound and they can injure dogs, lead to tracheal damage. They can, people are using shock collars, all in the name of because I think I need to muscle my dog, and it's just not how it has to be. So I'm here to help kind of dispel some of these myths that exist out there. And why do they exist out there is because anyone can be a dog trainer, and there's and the consumers, we've seen lots of models in television, and this is how we should relate to our dogs. And really, I could go on about this for 45 minutes because this are just the sort of basics, but please read my paper so you can get a better idea about really what goes on in dog learning. And yes, dogs learn safe versus dangerous, and we don't want dogs chronically stressed in their environments because there's sort of this lingering fear of, I don't know if I'm going to get a shock here, or I don't know that I can trust this environment there. The high cortisol levels in dogs lead to health problems. I mean, this is some of this is like low-level stuff, but it's their life. It's their life in the cushy house that you've made for them. And we all love our dogs and we want to do the best by them. But it's just, because there's this sort of no regulating of what information is coming to the consumers and how to deal with their dogs. The dogs are at the receiving end of a very mixed message, and so that's the basics. There have been efforts to improve the profession. People just on their own, kind of grassroots. There's certifications for being a pet dog trainer. There's the Association of Pet Dog Trainers that came about, trying to get, having conferences and educating people on, what methods should be used that are most humane. There's Karen Pryor. She's done wonderful stuff with her claim to fame. A lot of is dolphin training and using the clicker and incorporating that into positive reinforcement training for dogs. My own idea was that we could, maybe use a state licensure program to help to regulate the industry a bit. And in a recent case out of the Supreme Court, Justice Kennedy, sort of pointed out that there's a strong tradition of professional self-regulation, particularly with respect to the development of ethical rules. So having a licensure for dog trainers that would hold us to some standards and how we interact with dogs. I mean, just like you wouldn't, can you imagine that teachers in schools with children didn't have any type of license to be there? Your doctor didn't have a license to do any of the therapy on you. So paper, really try to be neutral and talk about, the pros and the cons. And licensure has its problems because people don't like, some people don't like a lot of government involvement. They like a free market, and that's all good. But this is an area where, I still think it's appropriate for animal protection. Otherwise, you're left sort of with just litigating it at the end where you've got an animal abuse case and the animal's been injured, and we don't want that. We want to prevent that. So here we have consumer benefits, consumer protection from unqualified workers. There are increases in average quality of workers. There's greater incentive for people to invest in themselves to get more education and increase their human capital. Then we get standards of care for the animals. And it leads to, they say, increased wages. That sounds all good. But criticisms, they're there. And that when you have a licensure, that it restrains competition in the marketplace, too much governmental control, you get the self-interest of the association, prices of services may increase, and there are barriers to getting jobs, and that all seems like a bad thing. You've got some states where you've got ridiculous, it seems like ridiculous, like, to be a florist, you have to have a license. To braid hair, you have to have a license. Well, but to train a dog, no, you don't need anything. So I say that I've noticed there are safeguards in place. There's antitrust laws, the Sherman Act. There are ways that protect against, a licensing board not exerting so much control over the market. in this 2015 Supreme Court case, North Carolina State Board of Dental Examiners versus the FTC, the court held that, these licensing boards they don't have state immunity. There was a dental case, there were teeth whitening, there are people who are giving teeth whitening services at malls, and they weren't dentists, and the dental association said, oh no, this is dentistry, and they served cease and desist letters to all these operations, and they all closed down. But the FTC brought this case in administrative arena, and eventually worked its way up to the Supreme Court. But to say that, you can't exclude all people. This definition does not fit what dentistry is. So, there are going to be ways to protect from this a board of dog trainers from squeezing every competition out. You as individuals with your pet, you can do anything you want with your within reason. No one's saying you can't train your dog at home, but if you're going to and paying for services, you should be you and your pet should be guaranteed some level of safety. Okay, so this is the composition of just what it might look like. 4 members, licensed dog trainers, veterinarians, Animal Protection Agency, 2 public members to represent the public's interest, and we have educational requirements. There'd be some field experience. I have to mention that I did find some states, New Jersey in 2000 and 2005 tried to pass some legislation for licensure. That didn't go anywhere. California has a certification for the blind dogs. You're going to teach blind dogs, or dogs for leading the blind. That they have to be certified. And there was an old law in 1976 in New Mexico. So there have been some efforts, but it just doesn't have a lot of momentum. There's not a lot of lobbying for this. So I hope somebody does pick it up. I hope somebody reads my article or just from here, talk. And, we could get some standardized practices. And very important, we want to employ positive, force-free methods of training as best practices and mandate that use of physical punishment in training must provide consumers with a disclosure of the risks associated with the use of punishment in their marketing materials, on their websites, and in their client contracts. Thank you.
We do have a couple of minutes for questions, if anyone has any. Go ahead.
So congratulations to all. These are real scholarly work, and we appreciate it. Question for Angie. Mm-hmm. How many of the dealers do you think could be attacked in the U.S. in terms of denying the deductions? I mean, how many could be identified? Do you think a successful action could be brought?
I don't know if this mic is on or not, so hopefully everyone can hear me. I'm not sure how many dealers it would affect. One issue is that with, people who are doing illegal business activities, they're unlikely to even report that income. They're not going to be paying taxes on it, so it would be hard to figure out who the dealers are, how many are out there.
If you had to guess, is it 2? Is it 20? Is it 200?
I don't have a guess. I know the U.S. market in illegal ivory is not as big as, certain Asian countries, but there is definitely a market here in the U.S. And, there's been so many states that are now introducing their own legislation against ivory trade, so it's probably a bigger number than I would guess, maybe somewhere in the hundreds.
Okay, thanks.
Mm-hmm.
I have a question. Elizabeth, in your time working with the doggy world, so to speak, have you spoken with dog trainers to see how they would feel about being regulated, what the overall sentiment is amongst them?
I mean, not, like, I haven't taken a poll. I mean, I get the sense that it's, from a little reading that, I mean, some are open to it, some are opposed, for sure. There would be resistance and there would be difficulties with, you know, and my paper talks more about it, just how to, you know, you've got people who are already established, so there might be like grandfather clauses, and that wouldn't really help the cause, because you still would be letting in people who may still not be really qualified to work with animals. But yeah, I think it would be meet with mixed reviews.
That's my sense too, is that some would want to be in favor of it because they could see what some of the other dog trainers are doing and think, oh my God, that person should not be a dog trainer.
Right.
And would help their own business, right? Because they want to get a good reputation and.
Right.
Do you have time for Carter's question?
Just quickly, yeah, for Caitlin, so if an animal advocacy organization, limited resources, is there one vulnerability in the KFO model that you would point them to target? One thing you would advise the next legal move?
You mean under the Clean Water Act or in general?
In general, of
In
all
general.
the things you listed, what would you recommend?
Well, I think this actually would be under the Clean Water Act, but citizen suits, I think, are underutilized. A lot of times, there is a provision in the Clean Water Act to bring a citizen suit, but it's not brought or utilized because citizens don't have resources to initiate litigation. And also they have to notify the EPA and the KFO before they bring suit within, I think, 60 days. Yeah, they're evading a lot of regulations, but I think that's probably underutilized.
Capitalizing that litigation would be one way.
Right, because most people who live near KFOs, I think,
Thank you.
don't enjoy it.
Any more? No? Okay, well, thank you again.
Thank you.